there was I guess sort of an artificial cap that had been placed on these damages throughout the years by the tribunal, and you saw damages in the range of $1,500 to $3,000, for cases years ago, and that was sort of trending upwards, with the idea being that there was this sort of general trend of a cap, if you will, of $20,000 in general damages in Alberta. But over time that has changed. Alberta's, I guess, followed suit with some of the other provincial human rights tribunals in awarding increased amounts in this area. So what are we going to get in 2022? We're only going to go up from there. And in 2022, there were 2 watershed cases setting new records for general damages in Alberta, both in the amount of $50,000. And we'll just quickly touch on these cases so that we can get an idea of what factors the tribunal was considering when they were making these awards.
So in 2022, we didn't see any decisions that we are aware of, at least on the merits, where a human rights tribunal anywhere in the country adjudicated on the merits of a religious exemption. So held that it was discriminatory or not, or that someone should have had a religious exemption. But this is in contrast to some labor arbitration boards, which also, of course, have the ability to adjudicate human rights claims for unionized employees. They took a bit of a different approach than in Pelletier. They applied sort of a lower threshold. And they said it will generally be sufficient evidence if a person is religious and says they sincerely believe that something is connected to their religion, or they must believe or act in a certain way because of their beliefs. So it's a bit surprising. There's been 4 cases that do apply this sort of lower threshold. So I think the open question for us is whether human rights tribunals will follow suit with that lower sort of threshold being applied in labor arbitration decisions, or whether it will stay truer to the Pelletier analysis, at least here in Alberta.
So the tribunal has a discretion under Section 28E of the Act to add parties to human rights complaint. And you'll see here that what the legislation requires is that any person specified by the tribunal on notice, and then the tribunal determines after that person has been given an opportunity to respond, they could make that person a party to a complaint. And so takeaways with respect to those 2 cases are that certainly a tribunal will be inclined to allow a request to add a party, in the event of corporate inactivity, where the ability to collect a remedy, a monetary remedy especially, would be jeopardized. So that would include, owners, directors, even majority shareholders in some case. But the tribunal is going to be less inclined to allow a request to add a personal respondent, where that's solely, due to the fact that that respondent is responsible or alleged to be responsible for the discriminatory conduct.